This is the 4th Annual Iona Campagnolo Restorative Justice Lecture. And I would like you to welcome our distinguished guest this evening, the Chief Justice of Canada, Chief Everson of the Comox First Nation, President Bowman of North Island College, and Dean Cran from North Island College. We will open this evening's event with a welcome to the lecture from John Bowman, one of our partners at North Island College in bringing this annual lecture to the Comox Valley. President Bowman.
Thank you very much, Bruce. Good evening, everyone. Madam Chief Justice, special guests, ladies and gentlemen. On behalf of North Island College, it is indeed a great pleasure to welcome you all to the 4th Annual Campagnolo Lecture in Restorative Justice. The annual lectures are co-presented by the Community Justice Center and North Island College, and I want to acknowledge the leadership of Dean Cran and the faculty from our criminology program who work closely with the center in the planning of the lectures. I want to stress also that North Island College is very, very proud of our partnership with the CJC, and we look forward to it continuing for many years to come. And while I have the microphone and podium, I want to take a moment to commend and thank the CJC Board of Directors, Chief Administrator Bruce Curtis, and the more than 150 volunteers who work to provide restorative justice services in the region. Their efforts are making our communities even better places to live. Please join me in a session of applause for these fantastic volunteers. We are also delighted this year to have as a co-presenter for the lecture the City of Courtenay Centennial Committee in honor of the 100th anniversary of the incorporation of the city. And I would be remiss if I did not mention that North Island College is also celebrating a major milestone birthday this year. It's our 40th anniversary. And we're looking forward to inviting you all to a series of events this coming fall to celebrate, and it's going to be a very exciting and positive year indeed. Look around the room. It's an impressive turnout, a wonderful attendance for this great event. And seated among you are many special guests, perhaps fortunately or unfortunately far too many for me to mention all specifically by name in the next 2 minutes, which is what I have. However, I do want to acknowledge just a few of our distinguished attendees. Chief Everson here from the Comox First Nation, on whose traditional territory we are gathered. The Honorable Thomas Crabtree, Chief Judge of the Provincial Court of BC, is with us. Ray Bernattis, Chief Superintendent of the RCMP Vancouver Island District, Colonel Tom Dunn, Wing Commander, 19 Wing CFB Comox, and Professor Brenda Morrison, the inaugural Campagnolo Lecturer, also with us. Representatives of the Vancouver Island and Sunshine Coast Restorative Justice Programs, many municipal and regional district representatives, plus members of the 48 organizations and agencies which have partnered with the Community Justice Center in a wide range of projects. And last, but certainly not least, I want to acknowledge members of the North Island College Board of Governors, staff and faculty and students who are with us this evening. The Campagnolo Lectures are, of course, named for the Community Justice Center's patron, the Honorable Iona Campagnolo, the 27th Lieutenant Governor of British Columbia. The lectures were inaugurated in September 2012 in honor of Ms. Campagnolo's 80th birthday, and, as you may know, have a mandate to bring to the Comox Valley the leading thinkers in the development and promotion of restorative justice as a preferred means of coming together to make things right. Previous lecturers have been given by Professor Morrison, Director of the SFU Center for Restorative Justice, Judge Barry Stewart, the Chief Judge of the Territorial Court of the Yukon, the Honorable Judge Ross Green, Provincial Court Judge of Saskatchewan. And as you know, this year's lecturer is the Right Honorable Beverley Mclachlin, Chief Justice of Canada. We are very honored indeed and proud to welcome her to the Comox Valley. Ladies and gentlemen, I'm sure we're going to enjoy a very informative and thought-provoking presentation. Once again, on behalf of North Island College, thank you so much for joining us this evening.
And now let us welcome Chief Rob Everson of the Comox First Nation to give their welcome to their traditional territories. Chief Everson.
Gela kasla, gela kas dakola lokolatle, nugo amne gedzi, gayotli lach Comoxa. First, I'd like to welcome you all to traditional, unceded Comox traditional territory. I welcome you all here today on behalf of the Comox First Nation. And before we get started, I'd like to also acknowledge the Madam Chief Justice's contribution to a decision that most of you know, the Tsilhqot'in decision, which for the first time in our history has given Aboriginal title to land. As a First Nations person, I can tell you that upon hearing that landmark decision in that case, it did something not only for myself, but for all of our people. It gave everyone hope. When I talked to the federal government and the provincial government before the Tsilhqot'in decision, the one thing that they always talked about was Section 35 rights. Well, since that decision last summer, what I've told them time and time again, it's not Section 35 rights, it's Section 35 rights and title. That's an important distinction for First Nations people all across Canada, and more particularly in British Columbia, where we predominantly do not have treaties with this great country of Canada. So on that note, and I'm sure that we'll hear more about that as we move on, I'd like to welcome you all here once again and acknowledge the fine work that has been done. Gela kasla.
And now we welcome the Honorable Iona Campagnolo, patron of the Community Justice Center, the founder of our feast, as Dickens would say.
My goodness, thank you so much. Before I begin, I would like to thank so many of you for the wonderful, supportive, and fun and interesting notices and notes you've sent me in communication since my accident, and I appreciate every one of them. Now I want to say something that I used to say 40 years ago, but in just slightly different context. I acknowledge with respect the Comox First Nation in whose traditional territories we are gathered tonight. When I used to say those words, there'd be a chill across the whole hall. Of course, I was speaking of the Northern First Nations with whom I grew up, and that was the Northern Protocol we had heard since we were young. And I am so happy to see now that it is said everywhere, all the time. It acknowledges that we as a nation are growing up, and it is long past time, as our wonderful guest tonight will be telling you. At the age of 37, Beverley Mclachlin was appointed to the County Court of Vancouver. A year later, she was elevated to the BC Supreme Court, and 4 years after that to the BC Court of Appeal, and in 1988, she became Chief Justice of British Columbia. In 1989, Beverley Mclachlin's meteoric rise culminated in her appointment to the Supreme Court of Canada. And 11 years on the 7th of January 2000, she became the country's 17th Chief Judge and the first female Chief Justice of Commonwealth Supreme Court. As of 2013, she became the longest-serving Chief Justice in the Canadian Supreme Court's 138-year history. In leading the court, the Chief Justice has implemented many of the practices of restorative justice into the working style of the court. She's led the court to become more a consensus-based, deliberative body, establishing the practice of communicating more in person and convening regularly as a group to carefully listen to each other's opinions. What a shocking idea. The number of unanimous decisions has risen dramatically. She has also expedited the process of coming to final rulings, giving timely answers to questions and issues being decided. The collegiality of the court is reflected in ways in their daily work. They actually had their office doors open. They had lunch together. They were known to have birthday cakes on certain occasions. Well, I understand the real Now that's a key restorative justice approach. Her court's decisions have reflected her view that they engage in an ongoing dialogue between the judicial and legislative branches of government, incrementally advancing and making changes to the law. In doing so, they are reflecting clear changes in the social values of the nation. Her court's decisions have reflected her view that they engage in ongoing dialogue. As a chief, she has authored many of the court's most important and high-profile rulings, including the 2007 decision that struck down federal anti-terrorism security certificates, 2001 Sharp decision upholding Canada's ban on child pornography, 2007 ruling that established a constitutional right to collective bargaining, 2011 Insight decision that kept open Vancouver's safe injection site for drug users, and 2012 Kawaja ruling, which upheld Canada's anti-terrorism law. Perhaps in keeping with restorative justice, effective use of the art, the Chief Justice has sat as presiding judge on 2 key trials in Stratford, Ontario. In 2013, the Chief Justice heard an appeal of the sentence of Shylock, but was unable to bring her contentious court to issue a ruling from the bench. In 2014, she presided over the case of Shakespeare and the Earl of Oxford, appealing the attribution of authorship of the Shakespearean canon to William Shakespeare. There she ruled that there is authorship of the Shakespearean canon, presumption of authorship rather, and the Earl's counsel failed to overcome that presumption. Nonetheless, she was not able to deliver a consensus from her contentious court in that case either. The arts are an extraordinary venue for judicial rulings, so perhaps it's not unexpected that these appear to be the only 2 cases the Chief Justice has presided over at Stratford and upon which no final decision has ever been rendered. During her tenure, the Supreme Court has become a champion of Aboriginal rights. It gradually developed and entrenched the notion that governments must consult and accommodate Aboriginal people to making decisions that could affect unproven rights and title claims. In June 2014, Chief Justice Mclachlin wrote the unanimous decision finally granting legal recognition of Aboriginal title of 1,750 square kilometers of territory to the Tsilhqot'in First Nation. You know who they are? They are the ones at the top of that dreadful road coming up from Bella Bella. They live on the Namaya Plateau. They're the ones with all of the wild horses. Well, for British Columbia, this groundbreaking decision could have major implications for contentious energy projects such as the proposed Northern Gateway pipeline, but it brings clarity to the kinds of outcomes that will be required from the treaty process as we advance in time. In a wide-ranging article in a Canadian Lawyer of 2013 on the eve of her becoming Canada's longest-serving Chief Justice. She was described as measured and modest and careful and contained, judiciously and pragmatically refraining from venturing too far afield. On behalf of the Community Justice Center, the North Island College, the City of Courtenay Centennial Committee, we welcome the Chief Justice of Canada, and it is my great honor to introduce you to the Right Honorable Beverley Mclachlin, Chief Justice of the Supreme Court of this nation.
Well, what can I say? Thank you so much, Ms. Campagnolo, for those much too generous words. And thank you all for being here tonight. It is such a pleasure to be amongst the people of the Comox Valley and those who have come from beyond. When I come to places like this, I feel once more connected to Canada in all its dimensions. It's very easy to stay in Ottawa and think that through reading and watching television and trying to keep abreast of issues, you know the country. But I know that I don't know the country until I experience an evening like this one. Thank you from the bottom of my heart. It is truly a great pleasure to have been invited to present this lecture. I have long admired Iona Campagnolo and admired her not just for her grace, for her honesty, for her integrity, but as an ardent proponent of whatever she sees as right and just, including the institute we celebrate tonight, and the lecture series which she instituted on restorative justice. If restorative justice plays an increasing role in Canada today, it is in no small part the result of Ms. Campagnolo's many contributions. And for me, it is a great honor to be, in some small way, a participant in this tradition. Restorative justice, justice that not only condemns, that not only decides, but justice that restores, has many facets and many applications. It infuses our tort law, it infuses our civil law, it infuses our law on Aboriginal justice. But most commonly it is thought of in the context of the criminal law, and in particularly sentencing in the criminal law. And that is what I wish to share a few words with you about tonight. But first, what do we mean when we speak of restorative justice in this area? And before I try to answer that question, which I will in a moment, let me take yet another step back to note how difficult it is and how important it is for a judge to determine a just sentence. Criminal sentencing is one of the most important and difficult functions a justice system is called on to perform. First, it's important. It's important to every woman, man, and child in our society. Members of the public quite happily ignore great cases from the Supreme Court of Canada, laws recently passed by Parliament, but they all have a view on sentencing. Sometimes they become quite emotional about and exercised about what they might see as an unfit sentence. We have all heard the refrains, maybe mouthed them ourselves: too short, too long, less often, too lenient, maybe too harsh. Everyone has an opinion. People may not understand all the legal facets that judges consider when they impose a particular sentence for a particular offender, but they all have passionate views on it, as I have learned in my over 30 years as a judge. Sentencing is important to people, but sentencing is also difficult. It's difficult for the parliamentarians trying to draft the laws and tell judges what they should be doing on sentencing. It's difficult for the lawyers who are seeking to advise clients in the courts on those laws. And it is difficult for judges who must actually impose the sentence. Ask any judge what he or she finds the most difficult part of her job, the most difficult area she has to deal in. And she'll give you usually one word: sentencing. Why do judges find sentencing so hard? It's not theoretically complicated. The basic ideas are fairly straightforward. Judges find sentencing hard for two reasons. First, because of the immediate and potentially devastating impact and effect the sentence will have on the offender who stands before the court, as well as the impact that an improper sentence might have on the community. If the offender goes to prison even for a short term, his or her life will be irrevocably changed, and the judge bears the burden of knowing that. The judge literally holds the individual's life in her hands. It is an awesome responsibility, and it takes a heavy emotional toll. So the first reason judges find it difficult is simply because it's so important and it has such great consequences for the offender and the community. The second reason I think sentencing is found difficult by judges is because of the diverse and contradictory goals that the law says should be achieved by sentencing, and which the judge must consider. The Criminal Code, Section 718, has no less than 6 of these that the judge is supposed to try to accomplish every time she imposes a sentence. She has to denounce the conduct, expressing society's condemnation and abhorrence for what has been done. She has to send a message that will deter other people from offending, as well as the offender, if and when he gets out. Thirdly, that it has to separate offenders from societies, especially dangerous ones. Fourthly, against all this background, the judge is supposed to find a way to rehabilitate the offender. And then, restorative justice goals which we all admire, have been added on in recent years. The judge should, if possible, find a way to compensate the victim for the harm she or he has suffered, and should try to make the offender understand and acknowledge the harms that crime causes to society. So how does the judge juggle all these balls? Well, the answer is something we call proportionate sentencing, and what it means is that the judge has to try to find the right balance between them. It's not always easy. Often the goals are in tension. Against this background, let me come back to the question I posed a moment ago. What do we mean by restorative justice in the sentencing context? The basic premise behind restorative justice here is that an offender's crime creates a breach in the fabric of the community. Communities function as units of mutual aid and accommodation. They are held together by a complex web of shared values, attitudes, practices, and rules. The most basic is the assumption of this mutual web is that members of the community must not hurt or harm each other. The person who commits a crime violates not only the individual whom he kills or maims or steals from, he violates the trust on which the community is founded. He inflicts a wound on the victim, but more broadly on the community as a whole. That is the first and most fundamental premise on which restorative justice in the criminal context is based. But this leads to the second premise, the premise that describes restorative justice and its goal. This premise holds that the task of the justice system should be to heal the breach of trust and the wounds the crime has inflicted on the individual and on the community. And beyond that, to heal the offender himself or herself. The elements of the theory of restorative justice that flow from these twin premises are by now well known. The process of restorative justice centers on the relationship between the offender, the victim, and the community. It's grounded in the need to share, to listen, to communicate, and to accept responsibility. Typically, it involves acknowledgement by the offender of responsibility, sometimes referred to as guilt, the expression, a fulsome, truthful, open expression of remorse, and negotiation in the sense of conversation and resolution with the victim, and beyond that, the community, so that the unity of the circle can be restored, pardon can be conferred, and life can be taken up again. At the end of the process of restorative justice, the wound inflicted, in theory at least, is healed, even though, as for any wound, scar tissue often remains. And at the end of the process, with luck, the offender himself is healed. He understands the importance of taking responsibility for his conduct. In the best of outcomes, he or she is rehabilitated and restored to the community as a productive citizen. Everyone is better off. That is the theory of restorative justice. It will be apparent that the process of restorative justice is very different from the sentencing process that you see on TV in mock trials, or that takes place in most cases in most of our courts on most days. The normal model, if I can call it that, pits the community against the offender in an adversarial process. The main focus is on the conduct of the offender, what message the sentence should send to denounce that conduct, and how much time, quote unquote, is required to deter the offender when she gets out and others who may be in the community from committing similar crimes. We've come some way to introducing restorative justice elements into this process, but arguably not far enough. Victims may make statements in what I call the usual or normal process, although this is still more the exception than the rule. And face-to-face engagement between the offender and the victim, much less between the offender and broader community, is difficult to achieve within the confines of the ordinary trial process. Not infrequently, as newspaper headlines often attest, victims emerge from the process angry and complaining that the sentence wasn't long enough to, quote, pay for, end quote, the damage the offender inflicted on the victim and the community. The vengeance motif sounds loud, and ancient refrains of an eye for an eye, a tooth for a tooth are muttered in the halls. The offender, for his part, is sent off to serve whatever sentence has been imposed. After a few years in prison, he or she will be released, and in too many cases, we know, will reoffend, beginning the cycle all over again. One hopes for better. Prisons struggle to rehabilitate the offender and change his attitudes. Many wonderful people, including among them those in the hall, volunteers and workers, work to introduce elements of restorative justice into the process, to change attitudes, to bring reconciliation between the offender and the community. This is important, but too often we are not doing a good enough job of it. I want to congratulate those in this room and those with whom I've talked tonight who have devoted such an important part of their time and their life to bettering the situation. But to go back to the theory, why is it, do you think, that we have two such very different notions about how to deal with people who commit crimes? One, retributive, that's the normal, usual trial process, talking about punishment and deterrence. The other, restorative. To answer this question, we must take, I think, a brief look at the history of restorative justice. And some of you might be surprised, as I was when I looked into this, that contrary to what many modern advocates of restorative justice sometimes seem to think, restorative justice is really a very old, indeed ancient idea. Indeed, the retributive system that today represents the dominant sentencing model achieved ascendancy only in the 8th or 9th century, relatively late in human history. Many of the elements currently associated with restorative justice, acknowledgement of guilt, expression of remorse, direct negotiation with the victim for restitution and pardon, were critical components of dispute resolution mechanisms adopted by early human communities. Criminologist John Braithwaite, after intensive studies of such societies, has concluded this, and I quote, "Restorative justice has been the dominant model of criminal justice throughout most of human history for all the world's people." A community and victim-centered justice system lies at the heart of the Code of Hammurabi, our first, probably, example of written law. The same ideas, along with a healthy dose of retributive thinking, to be sure, is found in the ancient Hebrew texts, which write of community peace in that lovely word, shalom, which means fulfillment, completeness, wholeness, the existence of right relationship between individuals, the community, and God. Shalom, it has been said, was the ideal state in which the community should function. Restorative justice, indeed. Wrongdoing destroys the relationship, and justice, restorative justice, restores it. The same themes can be found in Roman law, at least as it applied to Roman citizens, in many pre-colonial African and North American indigenous cultures, and indeed in indigenous cultures throughout the world. Such societies aimed less at punishing criminal offenders than at resolving the consequences to their victims. Sanctions were viewed as compensatory rather than punitive, intended to restore harmony in the community and the victims to their previous position. It's no exaggeration to say that the main function of the justice system, viewed historically, has been the restoration of the disturbed social equilibrium within the community. So writes R.B. Mbeki in the South African Law Journal. Well then, what changed? Why are we so far in our current practice in Canada from these ideals? How did the retributive system of criminal justice become the norm? This much we know. With the emergence of centralizing rulers around the 9th century, the restorative paradigm began to weaken. Hierarchical societies emerged in which the ruler took control over the administration and management of society, including criminal law. Around 1116, Henry I penned Legis Henrici, Henry's Law. I like the ring of that. This seminal legal document redefined offenses which had been thought of as crimes against the victim and the community up till then as crimes against the king. Transgressions of the king's peace, violations of the state order, the breaking of the state's law, condemnation, punishment, and banishment became dominant themes. In ancient conceptions of justice, the offender was required to compensate the victim. On the new conception of the king's justice, the offender was required to compensate the king. So we got fines which were paid not to the victim, not much less to the community that was injured by the crime directly, but fines paid to the king. It became a profitable exercise. Victims' rights compensation and imposing fines that were payable to the state made the administration of justice, in those days at least, a profitable institution. One scholar writes of Henry III, who, when he needed a few shekels, he needed funds, ordered his justices to go out into the land and find people guilty and impose monetary fines. It is said that during the 13th century, money collected from fines was equal to 1/6 of the king's revenues. The rise in popularity of the retributive justice model, the king's justice model, was abetted, of course, by some powerful religious ideas which were being put forward by powerful religious institutions around this time. On the European scene, the Judeo-Christian ethic, which had always had a strand of retribution, ever since Eve got thrown out of the Garden of Eden for disobeying God's command, was influential, as was the Judeo tradition of an eye for an eye, a tooth for a tooth, lex talionis. And in Muslim countries, the Quran too spoke of God as Allah, as the Lord of retribution. And even the Buddhist Dhammapada said that retribution follows bad acts, and the Bhagavad Gita linked retribution to bad karma. Fortified by these religious ideas, the king's justice took on a coloration of sin, which was by and large absent from restorative justice, earlier restorative justice models. The dominance of the punitive retributive model has remained largely unchallenged in the centuries since its adoption. At the end of 19th century, Canada adopted its first criminal code, and it was largely a document which sanctioned penal sanctions on the retributive model. As the father of the Canadian Criminal Code, a very respected man, English jurist Sir James Fitzjames Stephen put it, and I quote, but this was the way people thought, "I think it highly desirable that criminals should be hated, that the punishments inflicted upon them should be so contrived as to give expression to that hatred." But in the last 50 years, we have seen renewed interest in the concept of restorative justice. A single incident in 1974 in the small community of Elmira, Ontario, marked the beginning of a shift in the criminal law from the philosophy of retribution to the philosophy of restoration. Two young men, influenced by an excess of beer, went on a violent spree. It was quite a rampage, even by 21st century standards. Over a period of 2 hours, this pair slashed 24 tires, smashed the windows of a number of houses and a beer store, trashed a gazebo, broke some car windshields, punched a hole in a boat and overturned it, tossed a table into a fish pond, damaged a fence, broke a flashing light at a four-way stop, and just for good measure, snapped a cross off a church display case. Well, it's impressive. The judge in the case in Ontario, Justice Gordon McConnell, considered himself a law and order magistrate. But he was tired of the revolving door justice syndrome and seeing the same offenders come back again and again. And he decided to try something different. He therefore followed the probation officer's advice and ordered the two youths to meet their victims, find out the cost of their damage, and pay for anything that wasn't covered by insurance. Think of it as Canada's first restorative justice project. The offenders agreed to knock on the doors of all 22 of their victims and to explain who they were, express remorse for what they did, and propose to make amends. 3 months after their late-night rampage, the two delivered certified checks to their victims for the damage they had done. Just for good measure, however, Justice McConnell wasn't taking any chances. He fined them $200 and gave them 18 months probation. Well, the story, while it made headlines in Canada and beyond, and it spearheaded something of a wave of restorative justice. By the early 1990s, there were approximately 24 different victim-offender reconciliation projects in Ontario alone, and this soon spread across the borders into the United States, New Zealand, and Australia. As one author noted, hundreds of mediation programs in North America alone trace their origins to the Elmira case. Consider that, the power of one judge in one case to change the way people think. As news of the Elmira case spread, it caught the attention of those involved in the criminal justice system in Canada's northern regions. There, circuit judges frequently witnessed harsh and careless justice imposed on an Aboriginal population that too often did neither understand or accept the premises on which that justice was based. Exasperated by the significant overrepresentation of Aboriginal persons in prisons and encouraged by the success of the Elmira case, some of these judges decided to try something new and started introducing ideas of restorative justice, sentencing circles, talking, discussing, expressing remorse, agreeing to move on in the community together. At this point, it's worth pausing to note that Aboriginal groups in Canada, and indeed around the world, have diverse cultures, beliefs, and practices, and it's presumptuous to speak of Aboriginal teachings or Aboriginal justice as if it's one monolithic thing. Nevertheless, I believe it is true to say that underpinning these diverse cultures, beliefs, and practices is a profoundly restorative approach to crime and justice. Offenders are not seen first and foremost as sinners, but rather as people who have brought disharmony into the world, as people who are responsible to restore that harmony and the world order. The transgressor, the goal is, should be restored to the proper moral state and the breach with the community healed. British Columbia Provincial Court Justice Cunliffe Barnett was one of the first to reintroduce aspects of traditional Aboriginal justice into criminal proceedings by initiating community involvement in sentencing, which eventually evolved into circle sentencing. One of the earliest such sentences was in 1978 when he ordered a 14-year-old Aboriginal youth to be sent to a remote island rather than jail on the recommendation of his uncle and other band leaders. The island formed part of the band's reserves, and the teenager's uncle was working on a project that took him there almost every day. The teenager was isolated, but not abandoned. Separated, but not alienated. Spending 8 months, a considerable period, on the island, changed the boy's life, and he became a leader in his community. Despite these initial successes with restorative justice, formal adoption of restorative elements in the criminal code occurred not until 1998, when the elements I read to you earlier were introduced. Reparation, promotion of responsibility, acknowledgement of harm done. The same amendments also introduced a new penal sanction, the conditional sentence, which provided more flexibility to judges in fashioning restorative justice sentences. As a result of these changes, elements of restorative justice are now found throughout the Canadian criminal justice system. As the Supreme Court of Canada put it in the seminal case of Gladue, and I quote, "The enactment of the new Part 23 was a watershed, marking the first codification and significant reform of sentencing principles in the history of Canadian law." Nevertheless, we have not done enough. We have some restorative justice. We have some mechanisms that allow us to introduce elements of it into our process. Occasionally, we see it applied in its full force to even serious offenses. But the task of reconciling restorative justice goals with the retributive justice system that dominates our society, that is deeply rooted in our culture, is a difficult one. It will be a long work of progress, but we must not give up. I believe that we must work whenever we can, as judges, as lawyers, as community workers, to introduce the attitudes of responsibility, conversation, discussion, and healing into criminal law and into criminal sentencing and incarceration. Let me conclude. What can we take away from the brief history of restorative justice I've been talking about? I think a number of things, 3 at least. The first takeaway is that the restorative model of justice should not be understood as a new, gimmicky, untried, new agey, you pick your adjective, idea. It is a very old idea that has been with us since the beginning of human community life, since our first thoughts about criminal justice. The return to elements of restorative justice is a return to the roots of justice. It's not a new and untried solution. It's a badly needed recalibration of our criminal justice system. The second takeaway I'd like to suggest to you is that idealistic as we may be, optimistic as we may be, restorative justice must find a way to coexist with the dominant model of retributive justice. That model is deeply rooted in our culture, in our history, in our legal traditions. That model is here, in some sense, I believe, to stay for as long as anyone in this room will be there to see it. What we must do then is not present the either-or dichotomy and say, we are discouraged because it isn't all restorative justice. The way forward, as I've already suggested, is to keep working to introduce as much restorative justice into the system as we can. The criminal code amendments have shown us that this is what Parliament wants us to do. We need to find ways in our legal system to make it happen. A third insight, takeaway if you wish, which I'd like to leave with you, is that on the one hand, restorative justice isn't a panacea or cure-all to criminal conduct. But on the other, it's very important to a better justice system. Restorative justice is tough work, as those of you who labor in that field know. It requires dedication. It requires commitment. It is sometimes slow. It is sometimes costly, something taxpayers have to accept. And sometimes it involves taking some chances. It's much easier to lock someone up and throw away the key than to try to restore them to the community in a real sense, the real sense that is the goal of restorative justice. So, simply waving the magic wand will not cure our ills in society. But on the other hand, restorative justice is an immensely powerful idea that has proven it can change individuals, it can heal the wounds that crime inflicts on the individual and on the community. And indeed, in many circumstances, restorative justice stands as the only way to effect that healing, to move forward. So the takeaway is that the road is difficult, but we must follow it assiduously and with great determination. We have examples before us in the late 20th and early days of the 21st century. Let me leave you with the example of post-apartheid South Africa. The new country was faced with a terrible problem. A century or more of terrible systemic abuse of human rights and criminal conduct, a burden of anger and intolerance that resulted. What to do about it? The people of the new country engaged in a debate. Some wanted trials, punishment, imprisonment for those found guilty. But others said there's a better way forward. It's the way of restorative justice. And so a Truth and Reconciliation Commission was founded. It went about the country. Men and women of goodwill from both races sat on it. It heard terrible stories, It heard people tell of their broken hearts, their broken families. It heard confessions of odious deeds. It was not perfect. It had its critics. But victims and perpetrators listened to each other's stories and came to appreciate each other's experiences. That's very important because that's what restorative justice does. It takes us out of our solitudes and it asks us to appreciate each other's experiences. Through the act of telling, through the act of imagining yourself in the other's situation. Amnesty was offered to perpetrators who admitted their responsibility and provided full disclosure of their acts, and reparation was offered to victims in an attempt to, at least in a little part, address the harm they suffered. Restoration and reconciliation. Imperfect as it was, South Africa's truth and reconciliation process allowed that nation to deal with its trauma and move on. Could retributive justice, the Victorian model, the King's justice, alone have done that? I think not. We in Canada have our own Truth and Reconciliation Commission, which has been inquiring into abuses of Aboriginal children in residential schools. A huge program. An apology, a profound and sincere apology. I was there in the House of Commons, made by the Prime Minister to the victims of abuse of these children from our First Nations community. Followed up with a Truth and Reconciliation Commission under the guidance of a great Aboriginal judge, Murray Sinclair, and followed up by an attempt to listen to the stories of the victims and provide some sort of reparation. The last example I want to mention is Japan, where interesting innovations in the criminal law system have been introduced in the last couple of decades. There's a mainstream criminal system, which is much, in many respects, like ours. Judge, they even have elements of a jury, prosecutors, defense lawyers, convictions, maybe guilty pleas, sentencing process, separation, offender goes to jail, victim goes away, maybe unhappy. And that is the mainstream process. But the Japanese are introducing a collateral track, another track, where, on certain conditions, diversion can happen, and the person enters into the stream of restorative justice. And here in Canada, in British Columbia, our own provincial courts are doing the same thing. In Vancouver, you can visit diversionary courts, where instead of going through the usual formal process, people undergo a restorative justice process under the supervision of a judge who understands not only the difficulties of the situation, but the benefits to be secured in turning people's lives around and healing in the community. These examples should give us hope for a better justice system in the future. Whether we apply the principles of restorative justice to heal the wounds of systemic discrimination, as happened in South Africa and is happening now in Canada as we seek to deal with past abuses against First Nations, or whether we use the ideas of restorative justice to develop alternative tracks for offenders, this is now being explored here in Canada and in other countries like Japan. The ancient tenets of restorative justice offer a powerful way forward, a way that promises a more just, and unified society. As the Canadian Criminal Code has come to recognize, we don't have a choice. It's not a question of either retributive justice or restorative justice. We need to make both work in a way that restores our communities and those who offend their norms. Thank you very much.
Thank you, Madam Chief Justice, for your thoughtful comments and for reminding us of the historical context that gives rise to the tension between retributive and restorative justice. Also, a reminder of the relational connections between restorative principles and who we are as a society in Shalom. And finally, the reminder that we have a long ways to go. My name is Gregory Cran. I'm Dean at North Island College, and my role this evening is to moderate the question and answer period of this presentation tonight. My principal, my president, has the mic in hand. The idea is for you to ask succinct questions, and we will, in many ways, try to at least repeat them for the purposes of tonight's video presentation as well. So I will leave it to you to decide whether you wish to raise a question or not.
Thank you. The name's Haroon Bajwa, and I'm coordinator for Richmond Restorative Justice Program. Honored to be here, and thank you for that wonderful lecture. I think the question I have is one regarding resources. While I can see the goal of coexistence between restorative justice and our traditional justice system, it seems that one is very well funded compared to the other. And I'm just wondering whether that's something that needs to be explored and how we can go about bringing about a better playing field for those who do restorative justice work.
Well, you're quite right. Restorative justice can be expensive. I think setting up, for example, alternative courts can be costly, at least in the initial stages. In these times of tight resources, politicians have to make difficult decisions, and it's not for me to tell them how to make those decisions. But let me just leave you with this thought. It seems to me that sometimes when we look at this, how much does justice cost question, we don't take into account a full accounting of the benefits. One can make a case, and some criminologists do, that the traditional justice system is actually quite expensive. Let's not talk about the cost of employing judges and building courthouses and lawyers and all of those things. But beyond that, a system that leaves the community fractured, that may not effectively rehabilitate the offender, leads to future costs. So I think when we think about costs in the justice system, we should think not only of the immediate upfront cost of getting the case through now, police, judges, lawyers, etc., but we should also think about the future costs. And it may well be that restorative justice is a bargain. I don't know. but I'd like to see more research done on it. Because as you know, talking to the people who are working in this, as I have in downtown Eastside in Vancouver, the hope is that the cost to the community in shoplifting, in the endless cycle of people, often mentally ill and addicted, just going through the courts and back and forth, offending through the courts, back and forth. That endless cycle is expensive. It costs our businesses a lot of money. It costs a lot of money to incarcerate and treat these people over and over and over again. So somehow I'd like to find an accountant who would help me and put up a really good restorative justice calculation model. I hope somebody who's doing research in this now will take this up, because I think we could do it. And I'd be very interested to see, if we took into account the long-term results, where we'd end up on the cost basis. Thank you.
Another question here in the front.
Hello, my name is Debbie Neville, and I worked with the Restorative Justice Coalition at William Head Institution, a federal medium security prison, for 10 years, and a founding member of the Oak Bay Restorative Justice Society. But I could ask you lots of questions. But to stick to your topic tonight, I worry about minimum sentencing, which was in the United States, which has a lot of people pleading guilty just to avoid horrendous possibility of a 50-year sentence. And I know we're having more and more minimum sentencing in Canada. It's all decided before it even gets before a judge, because someone has pled guilty who might not even be guilty. So I wonder how that fits into your subject. Thank you.
I'm afraid I can't answer that question, because we have some of these cases before us right now, and it wouldn't be proper for me to address that question. I'm so sorry to disappoint you, but I'm going to have to leave it alone.
Yeah, I'd just like to go back to your historical example, because it certainly gave me pause. But when you cited that a lot of the historical example you used could be devil's advocate a bit, in that a lot of those communities were fairly small. People knew each other. They were really a community that had a lot to at stake in the social cohesion. Mm-hmm. But now, in sort of modern, where people are strangers and nobody knows each other, and the alienation that goes on, how can we bring that sense of community so that restorative justice can work?
I really appreciate that question. I had a page on that in my speech, and it was too long, so I cut it. But I just contented myself with saying restorative justice is very difficult. But I think that this is a real challenge. In smaller communities, one can see how negotiations within the community, the role of the elders, the people know each other and trust each other to some extent, even though there has been a violation. You can see that restorative justice must be much easier and more effective than it is in our complex multicultural society, where oftentimes people don't like each other very much. You're from the wrong tribe, or the wrong religion, or the wrong group, or the wrong side of the tracks, and why should I get together and have a conversation with you? So this makes it much more difficult, and it's part of a much larger discussion that we should be having, I think, in our society. We bridge the gaps between the different groups in our society, how we foster more trust and so on. But I'll just leave you with an example. In India, where I visited and had the pleasure of looking at the justice system, they have everything in India is so complex that what I'm going to say is oversimplifying. But you have the British model justice system, and then you have the Dalit courts, the ordinary courts that are in the villages. And India has over 1 billion people, And they have 56 languages, I believe. They have a lot of different people living together, some very different religions, Muslim and Hindu being the majority, and they don't always like each other. But these community courts are working in these Indian towns, I'm told. And that's the way a lot of the local justice is done. And when you ask about what's going on there, it is often a very restorative justice model. So I think even in complex, multi-religious, multicultural societies, there's some examples out there that we could look to and learn from. And it might be possible, but it's a difficulty, I agree.
Doug Hillian. I work in the provincial youth justice system, and I volunteer with the local community justice center. Thanks very much for your presentation tonight. I really agree with what you're saying, that the way forward is to bring more restorative approaches into our traditional system. I'm going to offend some of my friends from the legal community, though, by identifying a potential obstacle to that. When we have cases go through the traditional system, they're generally mediated by legal professionals. Now, we can delay the process in court if the lawyers need time for this, that, or the other thing, but it's very seldom that, in my experience, that the process is delayed to accommodate either the victim or any sort of reconciliation process. And I can give you examples where people will offer the opportunity of a reconciliation process and have a barrister say that I don't actually care what the victim thinks. I'm here to get the best deal for my client. So I appreciate that there are also champions in the system as well, and I applaud that, and we need more of them. I just wonder, though, if there are some institutional fixes that we could bring forward, and what you might think of a presumption in favor of, where, for example, the judge gives the opportunity in the pre-sentence period, after guilt's been established and before sentence is levied, of an opportunity for a conversation between the people harmed and those who've done the harm, a facilitated conversation that could take place with the outcome considered as an aspect of sentencing. There's nothing to prevent that within our system right now. And I think if some judges and some lawyers were prepared to champion that, people from the community would come forward to help facilitate those processes and bring about some hopefully better outcomes for those incredibly wounded people who have been hurt by crime as well as those who've committed it.
Very good comments. I agree. We need to move forward, and you make me think we need to introduce. Maybe we have already some of this in our judges training, and maybe we need to ensure we have even more, so that when new judges, people don't know this, but new judges actually go to new judges school. It's not much, but. A couple of weeks. And, maybe restorative justice ideas should be part of that. I don't know. I don't want to have a headline tomorrow saying that I said that, so please. I'm just musing, which is always dangerous. But I think it is a question of people getting used to the idea of restorative justice. It's great to see so many people in this room who understand the importance of it and are prepared to devote so much energy and time to it. It's a good idea, and I think as people understand it, they will embrace it, like Judge McConnell with the Almeric boys, Every once in a while you get a judge who says, need to try something new. And Chief Judge Crabtree is in that vein as well. So we hope things will change, but the old attitudes are there, and it's hard to make change in any profession, in any tradition.
Thank you very much. I appreciate your comments around the residential school. I was concerned about the restorative justice in terms of the multiple traumas that were experienced in residential schools. It seems to me part of restorative justice, or the main theme of it, is making it right. And when we have a court system that deals with First Nations that have been traumatized multiple times in residential school, how do we make that right for them in terms of maybe treatment? Treatment often is 6 weeks, and it doesn't even get to deal with any one trauma at any point. So the process of the people getting recycled through the court system and the damage that's been caused from residential schools, is there the potential to create long-term treatment to make it right for all those traumas that people have suffered? Because until then, it'll just keep cycling through the court system, and First Nations will be overrepresented in this system.
You're right, it's a huge challenge, and I think our justice system's struggling with it. You may have some. We need to somehow try to deal with the healing that has to happen. It's good to have apologies. I'm very grateful for that. It's good to have recognition of wrongs officially by the Government of Canada, and it's good to give some money to these people as a token of perhaps our understanding of what they've suffered. But more is needed. And as you know, the Criminal Code has some special sentencing provisions instructing the courts to take Aboriginal people's background into consideration, and we've written some decisions on this, and we hope that this will gradually help us change things in our justice system.
Well, thank you, Chief Justice, for a marvelously informative evening, a wonderfully engaging presentation, and for responding to questions from the people. And now we have come to the end of our evening together. And so, Madam Chief Justice, friends of the CJC, honored guests, it's now time to conclude the 4th Annual Iona Campagnolo Lecture on Restorative Justice. This lecture series was established to honor the patron of the CJC, the Honorable Iona Campagnolo, a fierce friend of restorative justice and social justice on so many levels. Previous Campagnolo lecturers, Dr. Brenda Morrison, Judge Barry Stewart, Judge Ross Green, have each deepened our understanding of the role and place of restorative justice in our work of justice making in the Comox Valley. They have each sought to broaden our understandings of our work. Madam Chief Justice, you have carried on this valuable work and broadened our understanding of RJ's role in the whole Canadian justice system, and brought us considerable encouragement to continue the work we are doing each day. We do have your musings on record. We will guard them judiciously. But if I get a chance to speak to the Attorney General, I may pull out my Google machine. More significantly, your acceptance of our invitation to deliver the 4th Annual Campagnolo Lecture has lent your luster and sheen to the place of these lectures in the intellectual life of the Comox Valley, and stimulated a lively conversation of where and how RJ can impact the lives of ordinary Canadians living our lives within community. You have shown how we can be more deeply attached to our better nature. On behalf of the CJC, our guests this evening, and the Comox Valley community, I want to thank you for bringing your thought and your grace to us this evening. Your Campagnolo Lecture will be remembered and referred to for many years. Thank you. We wish you a safe journey home and more years of judicial leadership in the Canadian Supreme Court.